and the Constitution of India allows me to disagree with the judgment. Because if we are not satisfied with this judgment, the law permits us to go for a review petition. And if review is rejected, that is not the end of the road. We can still go for the curative petition, and based on the advice that we have received from all the legal giants, is that if it goes for a curative petition, we can also appeal to a larger bench. That everything that was given to the Kashmiris was given by the Constitution of India. It was not given by any other foreign country. And India as a state believes in celebrating unity in diversity. You don't have a symmetrical approach for everyone. You believe in celebrating that diversity. That is why you have 371A to J. You have different concessions for the state of Nagaland, for Mizoram, for Arunachal, even for Gujarat and Maharashtra in some cases. Now, why do Kashmiri people, not only Kashmiri, you have legal giants like Mr. Falias Nariman, Rohingya Nariman, Mr. Madan Lokor, and even Prashant ji here. I will amply point out on the basis of technicality and where they have gone fundamentally wrong with the constitutional question.
The merits of 370, but let our lands and jobs be secure at least. This is not only J&K which has this peculiar characteristic of having a special status, as Mr. Kag has rightly pointed out. There are so many other states. Why we are being singled out?
On 11 December 2023 doesn't only have ramifications for the state of Jammu and Kashmir, but it means it was an assault on the constitutional relationship that was established between state of Jammu and Kashmir and the Union of India. Kashmir, as we all know, was a fully autonomous state right up till 1953. And what all we say and the narrative and the propaganda that is being propelled by the right wing, that these special provisions were only for the state of Jammu and Kashmir. A special boon was extended only for the people of Jammu and Kashmir is absolutely false. Like Mr. Kapil Kag Saab has amply said, there is 371, which is also temporary, transient, 371A to J. When you look at 371A, that is for Nagaland or for Mizoram, it clearly states that the Parliament of India has mandate to infringe upon or make laws regarding their religious laws, or in case of Mizoram or Nagaland, their social practices, only after getting concurrence from the respective assembly. The assembly of Nagaland or the assembly of Mizoram. And same was the provision as was with 370. Why do we respectfully disagree with the decision of the Honorable Supreme Court? Because all the petitioners, the principal case that had to be decided was regarding the constitutional relationship of Jammu-Kashmir with the rest of India. The autonomy as existed before 1953 was given by the Constitution of India. This is what people from Kashmir to Kanyakumari have to understand. From Gujarat to Northeast have to understand. That everything that was given to the Kashmiris was given by the Constitution of India. It was not given by any other foreign country. And India as a state believes in celebrating unity in diversity. You don't have a symmetrical approach for everyone. You believe in celebrating that diversity. That is why you have 371A to J. You have different concessions for the state of Nagaland, for Mizoram, for Arunachal, even for Gujarat and Maharashtra in some cases. That is why you had these special provisions, so that you can keep this diverse group of people together under this union. So that defined a relationship under 370. Now, why do Kashmiri people, not only Kashmiri, you have legal giants like Mr. Falias Nariman, Rohingya Nariman, Mr. Madan Lokor, and even Prashant ji here. I will amply point out on the basis of technicality and where they have gone fundamentally wrong with the constitutional question. Now, to abrogate 370, because 370 had a clause 3, which said that any change that had to be made in the pre-decided constitutional arrangement had to come after concurrence from the Constituent Assembly. But the catch is the Constituent Assembly was diluted in 1956. So what they have done on 5th August 2019 is that they have introduced a new clause by means of a presidential, presidential order, by a notification. It's not an order, it's by means of a notification, which is unconstitutional. This is what the legal luminaries are saying. Adding a clause to an existing article in the Constitution is not allowed. That is why 367D was added, this clause was added, that now the Legislative Assembly will serve and will be taken as the Constituent Assembly. This is where we focally disagree with the Honorable Court. And the Constitution of India allows me to disagree with the judgment. Because if we are not satisfied with this judgment, the law permits us to go for a review petition. And if review is rejected, that is not the end of the road. We can still go for the curative petition. And based on the advice that we have received from all the legal giants, is that if it goes for a curative petition, we can also appeal to a larger bench. We are not here only to discuss the technicality. It's to discuss the morality of the subject. This is not only pertaining Jammu and Kashmir. Like Sogata Das very amply said, the way they have blown to smithereens the Article 3. If a bill has to be introduced in the parliament, it has first to go to legislative assembly of that respective state. We did not have a legislative assembly at that time. Emergency powers were invoked. And then the governor, which was appointed by New Delhi, is giving a consent on behalf of citizens of Jammu and Kashmir. This is making a mockery out of this great democratic country. We might have reservations with what the previous regimes have done. It might be of any political party. But the constitution of this land has to be supreme. Yes, sir, I am concluding. I am saying that Prashant ji, in his August presence, I am saying, in light of Keshav Nanda Bharati's 13-judge constitutional bench, it has clearly said what is a simple amendment and what constitutes to altering the basic structure. In my opinion, the 11th December judgment has altered the basic structure of the constitution. And we, not only Kashmiris, people of India, from Kashmir to Kanyakumari, from Gujarat to Northeast, should all come together and say the way Article 3 has been ridiculed. A historic state has been broken down into 2 union territories. Now, I'll give you a very important fact. 39,000 square miles of land as it existed Jammu and Kashmir in 1950. By means of 5th August, 22,856 square miles have been usurped from me. Now my state, which used to be a state at one point of time, only has an area of 16,000 square miles. I am appealing through you to the conscience of people of India. And I am appealing the fourth estate also, media. It has to speak truth to its people. These are the promises made by the forefathers of India, the members of the Constituent Assembly of India. And we have to uphold those promises, not only made to the people of Kashmir or in Northeast, but in toto, we have to follow the constitution through which this country will run. I will like to sum it up with only one sentence, that all of us together have good intentions for this country. These are the things that were given by the Constitution of India. Let not one party dictate to us how rest of the people in this country are going to live. The way Article 3 and Article 370 was ridiculed through this judgment, it is not only a Kashmiri's duty to defend it in the Honorable Supreme Court. We have to educate our people what 370 actually was. Parag,
the merits of 370, but let our lands and jobs be secure at least. This is not only J&K which has this peculiar characteristic of having a special status, as Mr. Kak has rightly pointed out. There are so many other states. Why we are being singled out? You don't want us to have anything. You snatched everything that we had, even our statehood and our democratic rights as well. So please come to the rescue of people of Jammu and Kashmir.